So, hey, Gwilym, welcome back. We've both been away from the podcasting world for a couple of months, I think.
It's amazing. What happens? What do you do? What's going on?
Well, I don't know. I live outside of the kind of like the screen box because I've got used to seeing myself. So yeah, it's been a couple of months since. Well, also it's been a couple of months since I actually seen you. You only exist in this world now for me.
We had noodles.
Oh, we did have noodles. Yeah, we went to the noodle bar. That was good. I've just got back from Canada. I've just been to the IPIC, the Intellectual Property Institute of Canada's annual conference. So that was really cool last week.
Do you know what? That springs a question I've always wondered. How do you pronounce where you went?
St. John's.
Oh no, I can pronounce that bit. No, the three words they put together are new, found, and land. But how do you say
so I've had lots of Canadians laughing at me for all of last week because I obviously pronounce it in the way that I pronounce most things, in the way that it's spelt. So yeah, Newfoundland. No, Newfoundland. Newfoundland.
I thought it was Newfoundland. That's very British. It's a very British thing to do, that, isn't it?
They seem to take all of the vowels out. Yeah, is the way you pronounce it. So yeah.
Okay.
But I tell you what I did find over there, and I haven't necessarily noticed it in other parts of Canada when I've been there, but certainly in Newfoundland, they are the most courteous, kind car drivers anywhere in the world. So if they see you anywhere near the curb, and they could be 100, 200 yards away, they'll stop. And even if you're not going to cross the road, you feel obliged to cross the road because they've stopped. So I found myself zigzagging across the road because cars kept stopping. And apparently that's just how they work out there. They respect the pedestrian. The pedestrian comes first. If you're standing on a street corner, all of the traffic will stop so you can cross the road. It's nearly got me killed in London this week because I've forgotten that I've got back to London.
Can you imagine it? Like, how many cars are there?
Not many.
Like one. I was going to say it's like three. Yeah. Wow. Yeah, because I've done the opposite in Vietnam, where you just walk and don't look, and the cars swerve around you. Which is almost the exact opposite. Just going quickly to the lack of vowels. So, what would your name be if we took all the vowels out?
Ludivus.
See, mine doesn't change.
No, Gwilym,
that's what it is.
Rivets.
Yeah.
But no, on the more serious side, really good to catch up with the Canadians. We have a great relationship with our Canadian colleagues. You'll remember they came on the podcast when we were in
Indeed, yeah, that was fun.
So it was great to catch up with Paula and Kat, who were our guests then. And fascinating week looking at things like how regulation's going in Canada. So they've had their equivalent of IPREG in place now for sort of 3 or 4 years. So it's good to see how that's going, and to be reminded of all of those painful teething problems that you have when you bring on a new regulator, an independent regulator for the first time. Spent some time looking at privilege in Canada because that's an issue that attorney agent privilege. That's something we've been working with IPIC on, because that's something that agents don't currently enjoy in Canada as privilege because of recent rulings. Yeah, and obviously we talked about CPTPP. How could I go to Canada and not talk about the Comprehensive and Progressive Agreement of Trans-Pacific Partnership?
You said that so well.
I say it so well. I've lived it for so many years.
Well, we're in now, aren't we? Now Peru's approved this. Yeah. Thank you, Peru.
So big up to Peru for being the final. Are you a ratifiee? Is that what you are if you ratify something? But for ratifying and allowing the UK to join. We really ought to get Rachel on, because I'm conscious that she sat there listening to us.
That's what you do in podcasts, isn't it? Yeah, that was it.
Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
Hey, Rachel, hello, how are you?
Hello, very well, thank you.
So the score normally is that we ask you to introduce yourself. So can you sort of tell the listeners who you are, what you do, and why you're on the podcast, if that's okay?
Sure, yeah. So I'm a patent litigator, so UK qualified, also dual qualified in Ireland now, and I'm for 20 years now have been patent litigation specialist in the UK, but also an awful lot of kind of pan-European patent strategy advice. I'm based at HGF, so I'm in the mixed model firm that we have in the UK, and working with a huge team of patent attorneys on the patent litigation side of things. Yeah, that's my you didn't actually forewarn me about your discussion and where you'd been, but I have to tell you that I'm dual national Canadian. And
Oh,
I did in fact learn to drive in Canada. So I'm very well aware of the rules of stopping for a pedestrian when they're 300 yards away from you, which doesn't apply in the UK, I can tell you that.
yeah, no, I had to check it. So we went out for dinner with the Canadian, with the Epic board, probably second evening we were there. And it was so unusual. I had to ask, is this real? Am I experiencing this? I am expected to stop and cross the road. Yeah. If you don't cross the road, we'll hate you.
Yeah, you have to say sorry if you don't. That's definitely the rule.
I spent a lot of time with my hand, like I know people listening can't see this, with my hand in that kind of like, hey, hello, sort of like raised way. Either saying thank you for letting me cross the road, or yeah, no, not crossing.
Yeah.
So we're here to talk about all things UPC, particularly on the sort of practical side of it. So I'm going to ask my learned colleague Gwilym Roberts to lead on this one, if that's okay, Gwilym.
I'm very happy, as expected, not a problem. And I'm going to do what we normally do, which is we're going to start at the beginning. So,
Okay.
Rachel, can you talk us a little bit about how you got into litigation in the first place, what your experiences and so on? Where did it all start?
Where did it all start? So I not unlike an awful lot of IP solicitors, particularly on the patent side, have got a science background, but discovered fairly early on that the lab was not for me. But do love the science side of things. So when looking at law, very much attracted to IP, and I trained at a big international law firm with a really strong patent litigation team. And really, that's what I've been doing, patents and other IP rights for about 20 years now. And the UPC, because we're here to talk about UPC and kind of what's been happening. Obviously, we've been watching that for many, many years with the stops and starts. And one of the things that I've always sort of been part of is pan-European patent litigation strategy, and the UK in particular is it very much plays a sort of pivotal role in that and always has. And so, we could see the rules being built. We could see all these tools that, previously were only available in X country versus Y country coming together in this very exciting toolbox. And a kind of mix of civil and common law, obviously, because at the time the UK was still very much driving forward the development of the rules. And yeah, so it's sort of been a natural progression to now being involved, now that the UPC has launched, being involved in UPC litigation and kind of, that it is, I think, we really did hope actually it would be very successful. And I think after the first year, it has really shown to be very successful and it is a generational change in what European litigation looks like. And it is something that everyone, irrespective of whether, you're going to be involved or not, does need to be aware of, because it will impact on patent practice and patent litigation in Europe.
So starting, bear in mind that we have an audience from all kinds of different backgrounds, from hot litigators down through to people who think IP is interesting and want to learn a bit more. Maybe take a quick step back and just kind of talk about the regime before and after the kind of introduction of UPC as a starter, and then we can build up to some of the cool strategic stuff.
Yeah, sure. So, I mean, it's often quite a shock, particularly for anyone who's outside of Europe. The sort of the status quo before the UPC went live is you go through, most people go through the European prosecution as a sort of single process, and obviously there's the opposition process separately once it's been granted. But once it's granted, it's validated as a bundle. And the way that the system worked previously was, once you had a validated set of patents, any kind of validity infringement issues were dealt with primarily by the national patent courts. And that could happen in parallel with ongoing opposition proceedings, or, sometimes oppositions might go first and then you'd litigate afterwards. And I think it's quite difficult for people coming into it to really, it's quite a shock, I think. They'll come in and they'll say, okay, well, tell me how this patent, what might happen in Europe. And of course, you've got to break it down and say, well, this could happen in the UK, this could happen in Germany, this could happen in France, and it would all happen on different timescales. And they would say, hang on a second, you've got the same underlying law, you've got the European Patent Convention, and we'd say yes, but although it's the same underlying law, there are a lot of areas where obviously the different national courts are not particularly harmonised on issues. Whether that's doctrine of equivalence, the test that they apply for inventive step. And again, also potentially differs depending on which country you're in from what people would experience, what patentees and people looking to clear the way would experience with an opposition, for example. So that's sort of where we are. We've got the basic underlying law, but actually people did have to understand that things work differently in different countries depending on what was important. The UPC, and this is where we hope we will be, sort of 3 to 5 years out from the UPC starting. The real rationale behind it should drive proper harmonisation in terms of a UPC way of doing things. So when someone says kind of what's going to happen in Europe, you will actually be able to give them hopefully a clearer answer about their prospects of success, whether it's enforcing or defending. Obviously, there are countries like the UK that are outside of the UPC's jurisdiction. But what has always happened with the key patent courts, even the national courts, is although there's no obligation to take on board what a different national court has done, the judges at that level are very respectful of other courts and what they've got to say, and particularly the specialist jurisdictions. And so there should, in fact, be an influence, and we would hopefully drive harmonisation in terms of kind of the big items that are currently different. The other big thing as well is and it's a very practical thing, is timing was very different in different courts. You had the very fast courts, so the UK is fast, Germany infringement is fast, and the Dutch courts are fast, but other jurisdictions are much slower. Or with the bifurcated system in Germany, nullity wasn't an option until any opposition proceedings had happened. And that can leave people in a position where they were waiting several years to get decisions back. And now the very ambitious timetable that's been set in UPC proceedings is 12 months to a first instance trial. Currently, that's what's happening. And it is a huge difference for many, many jurisdictions. So, equally, you can also get revoked very quickly if you're a patentee, but you get clarity in a much faster time frame under the UPC.
So previously, if you got European patent and it was validated in 6 or 7 European countries, and you wanted to actually stop somebody infringing it, as we all know, you had to go and see them in all those countries, and then suddenly, at least for the UPC countries, and let's not go into which ones they are, it's most of the important ones except the UK. Now you can take a single action rather than 5 or 6, which is great.
Yes.
And that means, I guess, that it's a very powerful tool in terms of pan-European injunctions. Suddenly, I'm right in thinking that, well, okay, I do know, but basically you can suddenly take a single action and stop infringement across a huge swathe of countries. That's right, isn't it?
Yeah, that's correct. I mean, this is the big stick. This is the big incentive, really, for patentees coming into the system. And obviously, the question that we were looking at for the first year is how willing, on what terms will injunctions be granted? And we found very early on, the Munich local division granted a preliminary injunction on a unitary patent, so it covered all at the time 17 countries. That was actually overturned on appeal, but I think we have just recently, actually in the last couple of weeks, got the first preliminary injunction that has been upheld by the UPC's Court of Appeal, and we've seen quite a few PI decisions where a PI has been granted. We've also seen real scrutiny of the validity of the patent, the way that the infringement has been framed. So what has come out in the first year is the seriousness with which the UPC courts are taking the assessment of infringement and validity, even though it's not a full proceeding on the merits from a validity point of view, but it's important. And the other big trend that we've seen is kind of some clarity on what the urgency is. So how quickly do you have to get your action up and off to be able to actually be granted a preliminary injunction by the UPC?
And so breaking that down a bit again for the less familiar with bits of law there. So the preliminary injunctions is basically you want to go in very quickly, very early, and get an injunction quickly, pending a full decision, as it were.
Indeed.
So we've seen those coming out already. So basically, if you've got your product out there and it's being your patent, you're being ripped off, and it's causing you massive problems, you can go in fast, and that's, which is great. I think that's the kind of a tool that people need. The full injunction, just to clarify, you said that a full injunction had been issued, but it was overturned at appeal. Was it overturned because legally they can't give full injunctions, or was it overturned because the case didn't merit a full injunction, kind of thing?
So the case I'm talking about it was a preliminary injunction case, and it went up to the Court of Appeal. So it was granted at first instance, went up to the Court of Appeal, and the Court of Appeal effectively disagreed with the first instance course in terms of they felt it was more likely that the patent wasn't going to be held to be valid on a kind of full merits. So that was that. But we have seen recently a preliminary injunction that has been granted being upheld by the Court of Appeal.
Cool. So the courts are happy to give injunctions in the right circumstances. So it's a hugely powerful tool. And to the extent this goes out in the States and we're building an American audience, I think this is something that's obviously of real interest. And we'll get onto the international perspective in a minute. I just want to ask another couple of questions about the UPC and bringing it back a little bit, first of all. As you mentioned, you previously a UK litigator.
Mm-hmm.
Do you want to kind of paint a picture of some of the differences between running litigation in the UK versus running it at the UPC? It's kind of, it's civil versus common law in a sense, isn't it?
Well, it's interesting you say that. So the unique thing about the UPC setup is the rules are, in fact, a very unique blend of civil and common law. And that was obviously developed when the UK was much more involved. And although we haven't seen Ireland ratify yet, they obviously are a common law jurisdiction that we hope will come into the UPC. But what we've seen in reality is that it is currently all civil law jurisdictions that are participating. And we've not seen much uptake or appetite to use the common law tools like disclosure, expert evidence cross-examination, for example, and it has had a much more of a civil law flavour. So that's the way it looks like it's going now. Obviously, that could still change because things are still developing.
That's interesting because we had that Kevin Mooney on, didn't we? Really. We're asking some of the questions because he was hugely instrumental in setting this up in the first place, and remained instrumental, long after Brexit, basically, because of just how centrally been to all of it and how highly respected. He may still be highly influential, actually. I haven't heard from him for a little while. And one of the questions we had was, obviously, we had wonderful ambitions for this new hybrid court, as you say, with kind of UK style and continental style principles. And maybe unsurprisingly, given our diminished involvement, other than the fact that our EPAs can perform there, it is getting a more continental vibe. A little bugbear of mine is I have a little belief that the European Patent Convention, by the way, had the same thing. If you look at back end of the UPC, it's got a whole bunch of very British stuff in it that's never got used. Yes. Do you think there's a chance that the UK can influence a little bit more and get a bit more of the common law elements?
Yeah, I mean, what is very much we've seen is both the UK mixed model firms, so those who've got litigators and EPAs, and also the UK IP litigators, patent litigators, who primarily through the Irish route are very active actually in the UPC. And again, sort of picking up on this role that a lot of UK firms have always had, which is sort of being the linchpin for navigating, for doing a pan-European strategy. Whether actually on paper showing as a UPC representative, but or in fact being very instrumental in how it works with the UPC litigation, the UK is having a huge influence. I mean, obviously the biggest driver of cases has been in the German courts, and so there is currently a very German flavour. But we are seeing Paris and The Hague also, really handing down influential judgments as well. but we have seen pushback on things like cross-examination, for example, use of experts, not sort of discovery in the same way or disclosure that we are used to. But it has been a very rigorous procedure and very fast. So those sort of the speed thing is making a big difference, I think, to what the litigation looks like.
You mentioned that obviously things on the face of it, things got simpler. Suddenly you can get a single, so you get a single litigate, a single forum and litigate there and get your injunction for, was it 400 million people and all that kind of thing. The reality is it's not quite that simple still, is it? We still have national proceedings, we still have oppositions, and of course we have the countries outside the UPC, but which are part of the European patent system, the UK being a key one. So how are you seeing people playing this arbitrage, isn't it? There's a lot of options just at the moment. How are you seeing people play all these different elements to get the right strategy for Europe?
Yeah, you're absolutely right. It's another layer of forum shopping.
I didn't say that.
Yeah, well, it's true, because that's always the way you approach kind of what are we going to do is where's commercially important, where's the activity happening. All of those decisions are into play, and obviously we've still got European bundles which can be litigated in national courts versus unitary patents which have to be litigated in the UPC. So it's currently added a layer of complexity, because we are still seeing people have opted out. So there's still national litigation, but maybe a divisionals in the UPC. And that's really for very sophisticated players who've got deep pockets. And the other thing that we have seen in the first year with the UPC is people trying to see where the boundaries are of the rules. And so, we've seen a huge amount of procedural decisions, appeals on procedural decisions, because people are testing the boundaries, what is appropriate, what is going to be the UPC way of doing things. And on the substantive law, what does the UPC law look like? And people presenting, some people just, well, it's going to be like the German. And then other people saying, here's the Dutch way, here's the French way, here's the German way. And then, most people, I guess, would say, well, let's pick the way that suits our case the best. And the other area of tension as well, particularly on the validity side, is, what's the role of the EPO's problem solution approach? Because that's done differently in different national courts as well. So all of that in the first couple of years, I think, makes it more complex. Hopefully it will drive harmonization and we will get a UPC way of doing it. And then it will become more accessible to those who, don't have such deep pockets. But that said, Gwilym, what I found quite interesting is sort of more medium-sized entities who, they've got an issue and they're sort of really frustrated and they want to be able to perhaps stop infringement. And the UK is one of the most expensive jurisdictions, and they don't want to pay the £1 million plus that you're, with the potential cost risk as well if you lose, for one jurisdiction. But when you're talking about 17, now 18, versus the relative cost, and it can be done on a relatively sort of size, the good value. It's not cheap, but good value for the amount of jurisdiction that you're covering. Suddenly those companies that wouldn't have been interested before, or might have just perhaps done a German litigation, now can say, well, hang on, for the same price as a German litigation, I can get an injunction in 18 countries. So there's different considerations for the smaller companies as well, which again was, the UPC was supposed to be SME friendly. Whether it is or not remains to be seen, but certainly there's interest in the mid-size firms where they wouldn't have necessarily done so before.
Thank you. Actually, I've got lots of questions coming up your points there. But the first one was that SME thing, and the UPC was billed as, it's the future for SMEs. I don't think anybody ever believed that. It's really sad. You mentioned deep pockets, and we'll get to deep pockets, but there's middle-sized pockets too, which I think are very important. I suppose it it was built in this way. But I think what I'm hearing is that, maybe not your kind of, your little flower shop may struggle, but somebody with a decent business with a product in Europe, they don't have to have those super deep pockets to use the UPC. It is fit for purpose at that level.
Yeah, and there are discounts available in terms of the court fees for SMEs as well. So, if you can show that you fall within the definition, you do get quite a substantial discount. And there is also the availability, if you issue and you settle at certain stages, you can get some of the kind of upfront court fees back too. So there are some incentives there. Right now, it's, I think, quite difficult because it is a bit Wild West whilst things are being tested and things settle down. But when that works out, I think it will be attractive. If the business reason, the commercial reasons are there to do it, then it could be a really efficient way of. It won't be as cost effective as in opposition, though. I think that's sort of still also a very important part of. And from my point of view, I always think of oppositions as another jurisdiction because it's another really important place. It is a litigation because there's complete knockout. So yeah, it's balancing alongside that kind of route.
I always fond of the Wild West analogy, actually, because in the end, I guess the Wild West is always policed by a bunch of sheriffs. And yes. I do feel that our judges at the UPC, that they're good. So, yes, in the end,
very good.
Yeah, and I'm sure they talk to each other. And so that's good news.
Just to prove that I'm here and I'm listening, Gwilym, when we first launched our awareness raising program around UPC and the role that UK litigators would have in it, President Matt Dixon did, of course, refer to us as guns for hire.
Honestly, the analogies go on and on.
Yeah. I'll be quiet again now.
Matt's right, because one of the big things I think, kind of on a practical level, is because of the timescales and how much work is involved in these litigations, the size of your team, the depth of your, particularly on the technical expertise, how quickly you have to turn things around if you're a defendant, for example, and the sort of UK-based European patent attorneys, particularly with the English language really coming to the fore. The technical expertise, the language skills, the knowledge of the law is really useful. So that is something that definitely the UK can sell. And we're used to doing that as a sort of, the US comes into the UK quite often. So, and currently working with local co-counsel as well, whilst things settle down.
You have an uncanny ability to predict my next question, which was the international yes. element. So, I've heard some commentary from the US that, given that some US counsel seem to feel that the US is a bit anti-patent at the moment. You can't get injunctions. There's all these kind of challenges available at the USPTO and everything, that the UPC is being looked at as a potential alternative starting point for kind of a global strategy. Is that something you think is that a commonly held thought?
Yeah, no, I think it is. It is very much because of the jurisdiction, the territorial area, the value of the market that's being covered. It suddenly looks not quite at the level of the US, but similar to the US. And, what we're seeing is that validity is being very carefully scrutinized. So, you do have to have a good case, but then equally there is a willingness to grant injunctions, which in the US, preliminary injunctions are tricky. And also when you look at the cost of litigation in the UPC versus the cost of litigation in the US, there is it's a lot less, and it's currently a lot quicker. If you go into district court litigation or even ITC litigation, your ITC is minimum 18 months. District court, you're looking at years, and here we're talking about a really high quality decision on infringement validity within 13 months, 14 months.
Yeah. Thank you. That's it's good to hear that corroborated, because it's an exciting development. But I think it does bring, I've also heard, some potential risks in terms of the strength of the forum and the attractiveness of it, and the kind of a level playing ground, let's say, on validity. There were fears at the outset that it would therefore become a bit of an NPE playground, that it would be very attractive to businesses who litigate for their business to come to Europe because it's such a powerful sanction that people are more likely to settle instead of just giving them money and back off, which is, we know, a huge problem in the States. Is there a risk? Well, are we seeing that risk materializing, that we're going to see more litigation as sport, if you will?
That was a fear, definitely, that was in the minds of the committee who were drawing up the rules, and it's one of the reasons why we have cost shifting for a kind of loser pays principle, not on the same level as the UK, but on a sliding scale. There's if you lose, then you will have to pay some fees, and part of that was to deter just kind of non-practicing entities using it as a big stick to scare people. We have seen some activity from the non-practicing entities, not that much. That's not really been the main part of it. We have seen some settlements in that area. It's hard to know. It's hard to know. What we haven't really seen, or haven't seen visibly, is the role of litigation funders, which obviously is one of the big sort of drivers for non-practicing entities in the US. We'll see. I think the cost sanctions will put people off to a degree, unless they think they really do have a good case.
Good, which is a good thing, because I'm not surprisingly pro IP, but it does worry me that there's some areas where it can be gamed, and I think not necessarily on policy. So I'm pleased that we've got some provisions in place that block it. I've got one more, Lee, and you're back in the game, my friend. And I was to ask Rachel. So we talked about, the UPC is a new forum. It's got new law. It's a mix of lots of national laws. There's some British influence and common law influence. There's some. You mentioned the problem solution approach that EPO's favour and everything. What's your prediction for where the law is going to set up? Is it going to be a completely fresh look at IP law, or is it going to be very German, for example? Where's it going to sit?
Well, my hope is that, and I have heard on various sort of panel discussions where the judges have been talking about this particular issue, that they take the best of everything, because this is the opportunity to do it. Even a German judge, for example, will have some areas of the law where they think actually we've not, as a national court, gone the right way on that for whatever reason, or we've seen the Dutch court do this and actually we like that. So my hope is that it will be the best practices, and I think certainly the judges, you mentioned earlier, the judges very much are talking to each other. They're learning from each other. I mentioned we did the first saisi in front of the Paris local division, and we know that was being watched by many of the other judges, just to see what that looked like, because of course the Paris judges have got the most experience in that area at the national level. So I think my hope is that it will take the best of things, including EPO and across all of the courts that are involved.
Lee,
you're going to want me to come in now, aren't you? But
come on, we've missed you.
You've almost exhausted it, Gwilym. I wouldn't know. So the sort of things I'm interested in aren't really the practical stuff, though, Rachel. So it's more your feeling for how things are going. And so I was, whilst we've been talking, I've been looking back at when we did our sort of first piece of awareness raising around this. We introduced the concept of there being sort of 7 reasons why UK patent attorneys will be at the forefront of the UPC. So first question, are UK patent attorneys at the forefront of the UPC?
I have to say, to be fair to the Germans have done very well thus far. So I think it would be unfair to say that they're not really driving forward just because of the way where the cases have landed.
Yeah.
UK patent attorneys and UK firms have very much been involved in the development of the UPC in the first year. I think we've had a very strong influence on developments so far in cases. And we've always worked, the UK profession has always worked in international teams, whether that's within firms or with co-counsel in the different national courts. And I think that's what we've seen. And it has been a really exciting time and almost questioning, what you know from before, and actually, okay, well, do we have to do it like this? Is there another way of doing it? Did the Dutch do this better than we do? Or, actually we really want to push how we see this. That has really been very much part of the conversations that we've been having on cases.
So the other thing that crossed my mind whilst we were talking is so we hear in the conversations that we have that maybe the courts aren't so enthusiastic about EPAs as litigators. Is that something you've picked up on, or is that not? Is that just noises coming out of the courts?
I mean, so if you look at the way the court is set up, it's a very kind of German or Dutch model, which has always been a litigator with a patent attorney, and the way, when in the past, when we've sort of gone to hearings in the German courts or the Dutch courts, the court they're very short hearings. So the judges are like, okay, we've read your voluminous pleadings. We are interested in X, Y, Z. And as has always been the case in terms of kind of litigation, when before the Dutch court, for example, if one of the points is added matter, then it is going to be your EPA who is doing that discussion, and if there's a particular technical point. So I'm not sure that's the case in terms of as litigators. I think it's a team sport. Litigation is a team sport. And what has been really necessary across the litigation so far is big teams. And I think EPAs are a very crucial part of that, including at the oral hearings. Yeah.
Cool. I think I'm done, Gwilym. I think those are the only sort of things that crossed my mind whilst we were talking.
I have one more question then.
Yeah.
Oh, of course you do. Of course you do. This isn't your closer, is it?
No, No. What science degree?
Cell biotechnology.
Ooh.
Genetics and microbiology. Yes.
That sounds
Squishy
like a clever
things.
one. Squishy things. No, I get that. I was obviously hoping you'd say physicist, but I just always...
You always.
No, I went for the soft sciences, Gwilym.
The squishy sciences, yeah.
Well, Gwilym, we're bang on 40 minutes, because one of my jobs is to sort of keep an eye on the time. So we're bang on 40 minutes, which is sort of usually a good length of podcast for us. So Rachel, we normally finish with some kind of really highbrow intellectual closer. No, we don't. We normally finish with some kind.
I'm glad you're both shaking your heads.
Some kind of extraordinarily trivial closer, but normally it's my job to do that. But I got a message really early on in the chat from Gwilym saying, "Oh, I've got a closer. Don't bother thinking about one." So the way this works is he's going to ask me, which gives you time to think about your answer. You're going to answer, and then we throw it back at Gwilym as if he didn't know it was coming back at him. Again, I've given the game away, Gwilym. Maybe we'll edit that bit out.
No, don't. By the way, have you come across the word kayfabe?
The word what?
Kayfabe.
Spell?
I don't know actually. I think it's Kayfabe. Kayfabe.
No.
So it's a really cool thing that apparently comes from fairgrounds originally, and it's a pretense that everybody actively buys into, like the tooth fairy and that kind of thing.
Oh, okay. Yeah.
And all aspects of wrestling. So this is effectively a kayfabe.
It's a kayfabe. Okay.
Great phrase. I know exactly what they mean. The moment you say it, you know what it means.
you know, I'm Googling that at the moment we finish. So
I could be wrong, actually. This could be the kayfabe. I made it up. Right. So my closer. First it goes to Lee. I haven't actually got an answer myself. Oh, God, I should have thought this through. So anyway, at the very beginning, we talked about Newfoundland. And we talked about Canada, and we talked about dual nationality. So Lee, I don't believe you have dual nationality.
I don't have. No.
If you did, what would your other one? That's quite good, isn't it? What would you?
We've not done this one. That's such a cool question. If we did, what would my other dual nationality be? God blimey. I'm sort of semi-stumped. I'm sort of thinking German, because I've always quite liked Germany, and despite my sort of really bad attempts to learn the language, that would perhaps hinder me. So maybe I'd have to go somewhere that was English speaking. I love Canada. But that would be like sort of creeping too much with Rachel having dual nationality, wouldn't it? So I probably can't say Canada. New Zealand. I'll go New Zealand. Yeah. I'll go New Zealand.
Kiwi Davis.
Yeah.
Good.
Got a feel to it.
Right, Rachel, if you could have another, I assume you've only got dual, right? If you had a third, what would your third nationality be?
Well, it would be Irish actually. I'm in the very annoying situation of going back sort of a generation and a half and pretty much being entirely Irish family, but yet not quite qualifying for the Irish passport post Brexit. So if I could reclaim my Irish roots, I would love to do that. There we go.
Excellent, excellent.
Oh, there's somebody else in the room. Yeah, Gwilym. Forgot you were there for a minute.
Yes, me. Right.
Yeah,
Sorry. Yes.
yeah. So back at you.
Well, I mean, as you know, really, I never stop talking about my fervent Welsh nationalism, and I still regret the union.
Wait. But no, hang on. If you were a fervent Welsh nationalist, you would say there was never a union. Of course, it was.
Exactly.
It was an invasion and an occupation.
So I'm going to declare my existing dual nationality as British and Welsh. There you go.
Yeah, I can't do that because if I declare my Welshness, Charlotte, my exec assistant, always rips into me hugely saying you're just a fake Welshman, Davis.
Me too. That's exactly what I am.
Yeah, so I steered away from that one because it'll get me into trouble if it ever gets heard in the office. Not anyone listens to the podcast in the office. Oh, Rachel, thank you so much for coming on and sharing your experiences of the UPC. So this has been recorded just shortly before SEPA Congress. So you're going to do this again for us next week at Congress.
Yes, with a really exciting panel.
Yeah, yes. and this will go out after Congress. So we would have had the benefit of your experiences there as well. Really looking forward to that. Gwilym, I'll see you on the next one, mate. But I probably need to say to you that as this is the first one in the series, we've got a new jingle. How exciting is that? And it's a jingle that's really personal to you, isn't it?
Absolutely. No, it's double exciting. It's quite cool, the jingle. I think
absolutely love it.
We have a cut from it at the beginning, and then listening in at the end, you'll hear the whole thing. But yeah, well, my son wrote it. He's a very talented musician, and he's very good at putting things together. And it is super professional, and absolutely everything on it is him playing instruments with some fancy music mixing program, except for one bit, which is me singing Lee and Gwilym are. So there you go. I'm part of the experience, which I'm proud of.
I really love it. I love the bit that we've snicked out for the intro, and it's great that we're going to hear the whole thing at the end. And we're going to do a podcast on music when we're going to talk about the jingle as well. So at some point in this series, hopefully we're going to get little Gwilym on.
He's not that little. He's a lot bigger than Big Gwilym. Put it that way.
Yeah, they do outgrow you, don't you? I found that with mine.
I should name check him. It's Billy Roberts. Well done, Bill.
Yeah. So it'd be good to get him on when we're talking about music. So yeah, thanks again, Rachel. And Gwilym, I'll catch you on the next one. But before I go, what should people do if they've enjoyed this podcast? Can you remember?
Go for a swim.
Yeah, that's the second thing they should do. There's
All right, sorry. What was it? I'd gone. Shall I say it?
Yeah, go for it.
Leave us a review
on the podcasting platform of their choice, because that's how people find new podcasts, is they look at reviews, and hopefully we'll grow the audience that way.
Actually, if you just leave us a review, whatever you're reviewing anywhere, can you also add on? But even though this product wasn't very good, I recommend you listen to 2 IPs in the pod.
Yeah. On other people's podcast reviews. Yeah, leave it on other. Yeah. So
actually,
I'm going to go on. The rest is history immediately after this, and leave a review about 2 IPs in a pod.
Let's go viral. That's how you do it. Let's work it.
Thanks both.
Thank you. Bye.